Why contract law matters in real estate. Every part of a real estate transaction is powered by a contract. The listing that lets a broker market a home, the purchase agreement that transfers ownership, the lease that gives a tenant possession, the addenda and amendments that adjust dates and terms, the property management agreement, even the agency relationship itself. All are contractual in nature. To practice effectively, you do not just need to fill out forms. You need to understand what makes those forms legally binding, what can go wrong, and what happens when someone fails to do what they promised. Chapter 10 pulled together general contract law and applied it directly to real estate practice, with an Arizona focus, validity and enforceability at a glance. You began with the legal status of contracts: valid, void, voidable, and unenforceable. A valid contract meets all legal requirements and can be enforced in court. The core elements are competent parties, mutual consent, offer and acceptance, valuable consideration, lawful purpose, and a voluntary, good faith act. If one or more of those elements is missing, the agreement may be void. No legal contract ever existed. Or voidable, where one party has the right to rescind because of fraud, duress, mistake, or lack of capacity. Even valid contracts can be limited by enforcement rules. The statute of limitations restricts how long an injured party can sue to enforce or rescind. The statute of frauds requires certain agreements, including most real estate contracts, to be in writing to be enforceable. An oral long-term lease or oral sales contract might be valid as an agreement, but cannot be enforced in court if the other side refuses to perform. Once fully performed, however, neither party can use the statute of frauds to undo the result. You saw that much of contract analysis comes down to matching facts to these categories. A puppy sale example illustrated a valid contract where all 6 elements are present. An attempted sale of a neighbor's dog illustrated a void agreement because the object was illegal. A contract signed while intoxicated or under coercion showed how a contract can be voidable by the injured party. Confusing, vague terms written on a cocktail napkin demonstrated how a contract might be deemed unenforceable even if the parties tried to create an agreement. How contracts are created. You then moved into contract creation, how you get from negotiation to a binding agreement. The central process is offer and acceptance. The offerer proposes terms. The offeree has the power to accept, reject, counter, or let the offer lapse. Acceptance must be clear, unconditional, and communicated. Any change to the offer, whether price, dates, or even a seemingly small term, creates a counteroffer and extinguishes the original offer. There is no contract until there is a true meeting of the minds on all material terms. Revocation can occur any time before acceptance, unless the offerer has granted an option supported by consideration. Termination of an offer can arise from acceptance, rejection, counteroffer, revocation, lapse of time, or the death or insanity of a party. Once an offer is accepted and properly delivered, it becomes a contract, and different termination rules apply. You also saw how acceptance works in practice. The mirror image rule requires that acceptance match the offer exactly. Real-world examples, like a seller changing an expiration date or adding conditions on a BINSAR, showed how easy it is to turn what someone thinks is acceptance into a counteroffer instead. The mailbox rule and modern communication methods illustrated when acceptance is deemed delivered, once placed in the mail, or, in many cases, once transmitted by fax or email, depending on local rules. In commercial examples, you saw purchase orders treated as invitations to form contracts, and how acceptance can be shown by conduct, such as a vendor shipping goods. The law distinguishes between unsolicited gifts and true offers, explaining why receiving an unordered book in the mail does not obligate you to pay. From the real estate side, Chapter 10 connected these general rules to Arizona's Statute of Frauds and to Article 26 of the Arizona Constitution. Arizona licensees are allowed to prepare instruments incident to real property transactions handled by their brokerage, purchase contracts, deeds, leases, and related documents, but may not charge a separate document preparation fee and may not give legal advice. You saw how contract creation interacts with state-specific obligations for advertising, licensing, compensation, record keeping, agency relationships, and handling of funds. Throughout, the constant theme was that an offer sitting on a desk is not a contract until there is mutual consent, signatures by competent parties, and proper delivery. How contracts are classified next? You classified contracts in several ways, each of which shows up in daily practice. You distinguished oral from written contracts. Some oral agreements are valid and enforceable, especially short-term leases under 1 year, while others, like most sales contracts and long-term leases, must be in writing to be enforced under the statute of frauds. You saw that a parole or verbal agreement may partially exist in writing and partially by spoken word, but enforceability still depends on the subject matter and the applicable statute. You compared express and implied contracts. Express contracts are explicitly stated, either in writing or orally, with clear offers, acceptance, and agreed terms, such as a signed purchase contract or a verbal 6-month lease at a stated rent. Implied contracts arise from conduct. When you drop your car off at a repair shop or sit in a stylist's chair for a haircut, your actions imply that you will pay. Implied in fact contracts are based on a mutual understanding reflected in behavior. Implied in law or quasi-contracts are legal fictions courts use to prevent unjust enrichment, such as ordering payment to a doctor who saves someone's life in an emergency. Real estate examples brought this home. An agent who negotiates on behalf of a buyer without a written agreement might accidentally create an implied agency relationship, especially if the buyer pays a fee. Arizona Digest scenarios showed how a listing agreement signed by a seller and agent can be enforceable even before the broker initials it, because the agent had implied authority. Another example showed that a contract presented without a required loan status report could still become enforceable if the seller accepts it anyway, waiving the original condition. You also compared bilateral and unilateral contracts. Bilateral contracts involve mutual promises, such as a purchase contract where the buyer promises to buy and the seller promises to sell, or an exclusive listing where the broker promises diligent marketing and the seller promises a commission if the property sells. Unilateral contracts involve one party making a promise that the other can accept by performance, rather than a return promise. Options, contests, and reward offers are classic unilateral contracts. The option or must sell if the option is exercised, but the optionee is not obligated to buy until they act. Executed and executory contracts were another key classification. An executed contract is fully performed, such as the completed sale of a television, a closed escrow, or a lease that has run its full term and ended. An executory contract is still in progress. Promises remain to be performed, such as a signed purchase contract before closing or a cell phone contract, while monthly payments are still owed. The McDonald vs. Hewitt timber case showed how confusion can arise when performance is staged over time. Until the wood was cut, measured, delivered, and paid for, the contract remained executory, and title did not pass. Finally, you saw how contract delivery affects formation. A seller who signs a counteroffer but instructs the listing agent not to deliver it can still withdraw before delivery. No contract exists until the signed acceptance is actually delivered and received as the contract specifies. This detail becomes crucial whenever one party wants to back out at the last moment. How contracts end and what happens next. The last major topic in Chapter 10 was contract termination. Contracts can end in clean ways or messy ones, and the method of termination determines what remedies are available. Termination by performance occurs when both sides fully perform their obligations. Partial or substantial performance can also end the contract if both parties agree or a court finds that the essential purpose has been satisfied. Performance is the simplest and least risky way to discharge an agreement. Contracts may also terminate because performance becomes impossible or infeasible. A personal services contract may end if the person whose unique skills are required dies or becomes incapacitated. In real estate sales, the death of a party does not automatically terminate the contract. Instead, the estate may be required to perform. However, if financing was a contingency and the buyer's death causes the loan to be denied, the buyer's estate may recover earnest money based on the unfulfilled contingency. Parties can terminate by mutual agreement, sometimes replacing the old contract with a new one in a novation. Mutual cancellation of a listing does not always erase a broker's rights. A tail clause can entitle the broker to a commission if a buyer who saw the property during the listing later purchases within the protection period. Rescission can be voluntary or based on law. Statutory cooling off periods allow some buyers of certain types of property or lots to rescind without cause within a specified time. Courts allow rescission where fraud, concealment, or misrepresentation is proven, such as when a buyer's true identity is deliberately hidden through a straw buyer, and the seller would never have agreed had they known the truth. At the same time, the chapter made clear that home buyers in Arizona do not have a general 6-month right to rescind simply because they never personally inspected the home before closing. Revocation and abandonment are other practical forms of termination. Revocation is a unilateral attempt to cancel. It is always possible to announce, "I am done," but without legal justification, it may amount to breach. Abandonment happens when both parties simply stop performing without formally canceling. While abandonment may eventually be recognized, it is risky and uncertain compared to clear, written cancellation. Lapse of time also terminates contracts and offers. Listings expire on their end date. Offers with deadlines die if not accepted on time. Inspection and response periods in purchase contracts end automatically when the last day passes. When termination stems from breach, the damaged party has several remedies. Rescission attempts to unwind the transaction and return parties to their pre-contract position. Forfeiture requires the defaulting party to give up something, often earnest money. Damages compensate the non-breaching party. They may be liquidated. A reasonable predetermined amount, like earnest money in the AAR contract, or unliquidated, proven in court. Specific performance is particularly important in real estate because land is unique. Buyers can often seek a court order to compel a seller to close. Sellers may be able to pursue specific performance against buyers in certain circumstances. Arizona's cure process ties directly into breach and remedies. Under the AAR contract, a party is generally not in default until a cure period notice is properly delivered and the party fails to perform within the cure window. The effective date is the date of delivery, not the date on the notice. Once the cure period passes without performance, the non-breaching party can cancel, claim earnest money, sue for damages, or file an action for specific performance, depending on what best protects their interests. Tying it back to Arizona practice. Throughout Chapter 10, the general rules of contract law were tied specifically to the daily work of Arizona licensees. You saw how the statute of frauds requires written real estate contracts to be enforceable. Article 26 of the Arizona Constitution lets active, licensed brokers and salespersons prepare transaction documents for deals handled by their brokerage, but forbids charging separate preparation fees and limits licensees to their non-lawyer role. You also saw how Arizona law and AAR forms structure cure periods, inspection rights, cancellation options, and earnest money disputes. Digests and case summaries illustrated how BINSR responses, on or before closing language, missing loan status reports, and tail clauses play out in real cases. In every scenario, the core contract law concepts, validity, formation, classification, termination, and remedies, gave you a framework to interpret the facts and anticipate outcomes. For an Arizona licensee, Chapter 10 is not just theory. It is the legal backbone behind every form you complete, every date you track, every cure notice you send, and every conversation you have when a deal starts to wobble. When you understand contract law, you are far better equipped to explain options to clients, spot risk, and know when to involve legal counsel. Review summary. In this snapshot, you reviewed the entire flow of Chapter 10 in one place. You started with contract validity, learning how to distinguish valid, void, voidable, and unenforceable contracts, and how the statute of limitations and statute of frauds affect enforcement. You saw the essential elements of a contract: competent parties, mutual consent, consideration, lawful purpose, and voluntary good faith agreement, and applied them to simple and complex examples. You then revisited contract creation through offer and acceptance, counteroffers, revocation, and delivery. You examined how acceptance can occur through signatures, mail, fax, email, or conduct, and how the mirror image rule and mailbox rule govern this process. You connected these general principles to Arizona's Statute of Frauds and Article 26, which define when contracts must be written and what documents licensees may prepare. You recalled how contracts are classified: oral versus written, express versus implied, bilateral versus unilateral, executed versus executory. You saw implied agreements in everyday life and in real estate agency, recognized unilateral contracts like options and rewards, and learned to distinguish a completed transaction from one still in progress. Finally, you summarized contract termination and remedies. You saw termination by performance, impossibility, mutual agreement, rescission, revocation, abandonment, lapse of time, invalidity, and breach. You reviewed the tools available when things go wrong: rescission, forfeiture, damages, and specific performance, and saw how Arizona's cure notice process and earnest money provisions turn theory into practice. At every step, the chapter emphasized that understanding contract law is not optional for real estate professionals. It is fundamental to protecting clients, complying with Arizona law, and managing risk in every transaction.